Tonight, a long-simmering controversy surrounding the Jeffrey Epstein case has returned to the center of American political debate, triggering a sharp public confrontation between Democratic Congressman Eric Swalwell and former Trump administration official Kash Patel. What began as renewed discussion over the handling and release of Epstein-related documents has escalated into a broader argument about transparency, accountability, and whether political influence has shaped what the public is allowed to see. At the heart of the dispute are allegations, counter-allegations, and unanswered questions surrounding the Epstein files, a collection of court records, investigative materials, and testimonies tied to the late financier, whose crimes and connections continue to cast a long shadow over U.S. institutions. While no new criminal charges have emerged from this latest exchange, the political stakes have risen sharply. Swalwell, speaking publicly and through social media statements, has accused Patel of helping enable what he characterizes as a broader effort to shield former President Donald Trump from scrutiny connected to Epstein's network. Patel, in turn, has categorically denied any wrongdoing, calling the claims politically motivated and unsupported by evidence. The exchange has reignited public interest in a case many Americans believe has never been fully explained. To understand why this confrontation matters, it's important to revisit what the Epstein files are and what they are not. Jeffrey Epstein, who died in federal custody in 2019, was convicted in 2008 on state charges related to sexual misconduct and later faced federal prosecution for sex trafficking of minors. Over the years, numerous court filings, civil lawsuits, and investigative records have referenced a wide range of powerful individuals who associated with Epstein socially or professionally. Importantly, appearing in these documents does not, by itself, indicate criminal wrongdoing. Still, the perception that influential figures may have received preferential treatment has fueled public distrust for years. In recent months, renewed attention to unsealed court documents and calls for greater transparency have brought the issue back into the spotlight. Advocacy groups, journalists, and some lawmakers have argued that the public deserves clarity about how Epstein operated, who enabled him, and whether institutional failures allowed his crimes to continue. It is within this environment that the current political clash emerged. Congressman Eric Swalwell, a Democrat from California and a member of the House Judiciary Committee, has long positioned himself as an advocate for accountability in matters involving national security and the rule of law. In recent statements, he has suggested that figures aligned with the Trump administration, including Patel, played a role in shaping narratives around the Epstein case in ways that minimized scrutiny of Trump's past associations with Epstein. Swalwell has been careful to frame his remarks as questions of transparency rather than direct accusations of criminal conduct. Nonetheless, his language has been pointed. According to Swalwell, the issue is not whether Trump committed crimes related to Epstein, something no court has established, but whether political actors worked to suppress or discredit lines of inquiry that could have proven politically damaging. Kash Patel, a former Department of Defense official and senior advisor during the Trump administration, has responded forcefully. In interviews and online posts, Patel has denied any involvement in suppressing Epstein-related information and accused Swalwell of using the tragedy of Epstein's crimes for partisan gain. Patel has argued that he had no authority over judicial processes related to Epstein, and that claims suggesting otherwise misunderstand both his role and how federal investigations operate. He has also pointed out that Epstein's most significant plea deal occurred years before Trump took office, under a different administration. This factual point has been echoed by multiple legal analysts, who note that Epstein's controversial 2008 non-prosecution agreement was negotiated during the George W. Bush administration. However, critics counter that the broader handling of Epstein, including the circumstances surrounding his death and the pace of document releases, spans multiple administrations and institutions. That complexity is part of what makes the issue so politically combustible. The current showdown is less about new evidence and more about trust. For many Americans, Epstein's case represents a symbol of perceived elite impunity, the belief that wealth and power can insulate individuals from accountability. When lawmakers argue publicly over who bears responsibility, those underlying frustrations resurface. Swalwell has framed his challenge to Patel as part of a broader demand for institutional transparency. He has called for clearer timelines, fuller document releases, and stronger protections for whistleblowers who may have information related to Epstein. Patel, meanwhile, has emphasized due process and cautioned against what he describes as innuendo-driven politics. He has warned that implying guilt by association undermines legal standards and risks damaging reputations without evidence. Both positions resonate with different segments of the public. The legal reality is that many Epstein-related documents have already been released through civil litigation, often with redactions. Courts have gradually unsealed records after balancing privacy rights, ongoing investigations, and public interest. This process is slow by design and not controlled by any single political actor. That has not stopped speculation. Social media has amplified claims, counterclaims, and conspiracy theories, often blurring the line between verified facts and assumptions. In this environment, political figures' statements can quickly take on their own life, regardless of intent. Media scholars note that the Swalwell-Patel exchange fits into a broader pattern of modern political conflict, where accountability debates are conducted in public forums rather than courtrooms. These debates can influence public opinion even when they do not produce legal outcomes. So far, no evidence has emerged demonstrating that Patel, Trump, or Swalwell personally interfered with Epstein-related investigations. Still, the debate continues because it taps into unresolved questions. Why did Epstein receive lenient treatment in the past? Why did oversight mechanisms fail? Why did it take years for some documents to become public? These questions transcend any single political figure. The Trump factor, however, ensures that the debate remains highly polarized. Trump's documented social interactions with Epstein in the 1990s and early 2000s have been widely reported. Trump has stated that he severed ties with Epstein years before Epstein's arrest and has denied any involvement in Epstein's crimes. No charges have been brought against Trump in connection with Epstein. Nonetheless, critics argue that Trump's broader relationship with powerful figures raises legitimate questions worth examining. Supporters argue that those questions have already been answered, and that continued focus represents political harassment. This divide shapes how Swalwell's challenge and Patel's rebuttal are interpreted. From a legal standpoint, the Epstein files are unlikely to produce sweeping revelations at this stage. Most criminal liability related to Epstein himself ended with his death, and civil cases against associates face high evidentiary thresholds. That does not mean the documents lack significance, only that their impact is more likely to be historical and institutional than prosecutorial. Still, the political consequences are real. Swalwell's comments align with ongoing Democratic efforts to frame Republicans as resistant to transparency. Patel's response aligns with Republican efforts to frame Democrats as weaponizing allegations without proof. Neither side appears inclined to de-escalate. What makes this moment different is timing. The showdown occurs during a period of heightened distrust in institutions, ongoing debates about executive accountability, and renewed focus on past abuses of power. In that context, even unresolved cases like Epstein's can become proxies for broader arguments about governance. Public reaction has been mixed. Some Americans welcome renewed scrutiny, believing that uncomfortable questions must be asked regardless of political consequences. Others express fatigue, arguing that endless controversy without resolution erodes confidence rather than restoring it. Legal experts caution that conflating political responsibility with criminal guilt is dangerous. They emphasize that accountability can take many forms: reforms, transparency, oversight, not all of which involve prosecutions. As of tonight, no congressional investigation has been formally launched specifically targeting Patel or Trump over Epstein-related matters. No court has issued new findings. What exists is a public confrontation, one that reflects unresolved tension rather than resolved facts. Whether this showdown leads to concrete action remains uncertain. It could prompt renewed calls for document review. It could fade as attention shifts elsewhere. Or it could become part of a larger narrative as election season intensifies. For now, it stands as another reminder that Epstein's legacy is not confined to the crimes he committed, but extends to the questions institutions failed to answer clearly. In the end, this dispute may say less about Epstein himself and more about the political environment confronting his case. A system struggling with trust, transparency, and credibility inevitably revisits its most troubling failures. Tonight's exchange between Swalwell and Patel does not resolve those failures, but it does underline them. And until the public feels that the full truth, whatever it may be, has been responsibly examined, the Epstein files will continue to resurface, triggering confrontations like this one, not because of what they prove, but because of what they leave unresolved. As this debate unfolds, it raises a deeper and more uncomfortable question. What does real transparency actually look like in the modern American system? For years, the Epstein case has functioned as a stress test for institutions that claim to uphold justice without fear or favor. Each time new documents are released or public figures clash over responsibility, the same concern resurfaces. Is the system capable of investigating itself honestly when powerful interests are involved? This is where the Swalwell-Patel confrontation takes on added meaning. It is not simply a dispute between two political adversaries. It reflects a broader anxiety that accountability mechanisms may be vulnerable to political pressure, or at the very least, political interpretation. Supporters of Swalwell argue that asking difficult questions is not an attack, but a necessity. From their perspective, transparency does not threaten democracy, secrecy does. They believe that even the appearance of influence over sensitive cases erodes public confidence and demands scrutiny, regardless of party affiliation. On the other side, Patel's defenders argue that process matters. They warn that transforming unresolved questions into implied conclusions risks undermining legal standards that protect everyone. In their view, accountability must be grounded in evidence, not suspicion amplified by political rivalry. Both arguments expose a core tension in democratic governance. How do societies demand openness without sacrificing fairness? That tension is not unique to the Epstein case. History shows that when institutions fail visibly, whether through lenient plea deals, delayed disclosures, or unexplained decisions, the resulting vacuum is often filled by speculation. Once trust is damaged, restoring it becomes far more difficult than protecting it in the first place. The Epstein files, fragmented and released over time, have contributed to this dynamic. Each partial disclosure answers some questions while raising new ones. Redactions, sealed names, and legal delays